morning, everyone, and welcome to the New Possibilities Hour, part of the Will Work for Food project, founded by Natalie Armstrong-Motin in the spring of 2020. Every week, Jean Lawler and I are delighted to host another cutting-edge webinar for mediators, arbitrators, lawyers, and everyone who negotiates. Today is May 4th, 2023. We've been at it now almost 3 years, and one of my favorite parts of the program every week is when we announce the running total of just how much our generous audiences have contributed in honor of our great speakers. Jean Lawler, would you please do the honors?
Oh, it'd be my pleasure, and happy birthday to the New Possibilities Hour. As of now, the amount is $393,626.42, of which we have been told, I will highlight. So that's give or take 4 million meals. So that's wonderful. Thank you all so much.
Fabulous, fabulous. Thank you all so much indeed. And today we have another terrific program, One Memorable Mediation, presented by Jonathan M. Palmer. Jon Palmer serves as Corporate Vice President and Deputy General Counsel at Microsoft Corporation. He leads Microsoft's litigation department, including the e-discovery and corporate records management teams. Before Jon joined Microsoft, he was a litigation partner at Orrick, Harrington, and Sutcliffe LLP, and before that at Heller Ehrman LLP. From 2005 through 2008, Jon was based in Asia, where he was managing partner for Heller Ehrman's offices in Hong Kong, Singapore, Beijing, and Shanghai. Jon received his BA from Stanford University in 1988 and his JD from the University of California, Berkeley in 1993. Jon, welcome. We're looking forward to hearing you tell us a little bit about the food bank to which you would like people to contribute if they're in a position to do so. And then One Memorable Mediation. Jon, the floor is yours.
Well, thank you. Thank you, Jeff. And yes, let me start with a plug for the food bank. It's the University District Food Bank here in Seattle. It's very close to my home. My sons both volunteered there when they were in high school. Last year, that food bank distributed over 2.4 million pounds of food, had 58,000 customer visits to their facility, to their storefront, and served 1,500 households per week with groceries that they needed to make meals, including 400 homebound customers. So it's a very active food bank, and I thank you for considering that a donation there. Really appreciate it. And this is a great way to raise money for people in need and cross that $400,000 threshold. So thank you. Jeff, are there other questions? All right, great. Well, let me just start by saying it's a little bit intimidating to talk about mediation to a group that like this that really focuses on mediation, and many of you, if not most of you, are ADR professionals. I am not. I am, however, a consumer of mediation services and have been a consumer of mediation services for 30 years or so. So I thought that maybe one way to approach this would be, as a consumer, really looking at one mediation and trying to pull it apart a little bit and ask myself, as a participant, what made it work, and try to draw some insights there, and perhaps you all can draw some of your own insights from it. So let me just kick it off with that and see if this slide forwarding works. Okay, can you all see? Okay, great. So let me just start with the dispute itself. This was really 3 separate consumer class actions filed in Canada, in 3 different provinces: Ontario, British Columbia, Quebec. But it was a nationwide class ultimately. The plaintiffs' class, they were purchasers of Microsoft Windows and Office products, obviously cornerstone of Microsoft's business, filed by both consumers and enterprise customers. This really was a case that was launched in the aftermath of the landmark antitrust litigation against Microsoft by the federal government of the United States, and then ultimately before the European Commission. And so a lot of the same conduct and claims were involved. There was also, incidentally, many years of private class action litigation in the United States following that landmark case brought by the Justice Department. So we had 25 years of business conduct spanning multiple categories, multiple products, 10-year damages period, overlapping substantive law, US, Canadian, EU law, very novel economic analysis. 14 years of litigation. This went up to the Canadian Supreme Court on a standing issue, came all the way back down. There were 23 million documents, 221 depositions, extensive third-party discovery, concurrent proceedings in multiple jurisdictions. Trial commenced in May of 2016, and then we reached a mediated settlement in principle in February of 28. So you get it. It was complicated. There was a lot of complexity here, a lot of moving pieces. You know, that's the bottom line. By the time we got to mediation, 2 years into trial, 14 years into litigation, 20 plus years into these issues, there was a lot going on. So let me talk a little bit about the stakeholders. We had, obviously, I had very capable counsel QC in British Columbia. The first case commenced in British Columbia and Vancouver. Very capable class counsel on the other side. Class counsel on the other side of the case, the plaintiff's side, really was lead for a whole set of stakeholders in Canada, including in Ontario and Quebec and others in British Columbia. And the case had been syndicated originally by US class counsel who had litigated the cases, very similar cases, although not entirely overlapping, but similar in the United States and many states. So we had that on that side. And then of course we had Microsoft Canada, we had Microsoft Corp. And, there was a good relationship and a long-standing professional understanding between my counsel and lead class counsel, but I also developed a relationship with lead class counsel over time. And of course, I had been involved in these matters for a long time, so I knew the people in the United States as well. I knew the class counsel in the United States and had worked against them and in various settings for many years. So we were familiar. So let me talk then a little bit about the settlement, and I should say I will leave time at the end for questions if questions come up. None of this information is confidential or privileged. This is all public information. Obviously, it was a class settlement that had to be approved by 3 courts in Canada. So we reached this framework in February 2018. Again, as I mentioned, in the middle of trial, technically. The basic features: there was a dollar cap, there was a claims period followed by distributions to class members. All that's typical. The enterprise class members receive distributions in the form of vouchers that can be redeemed to purchase Microsoft technology. And following that, a portion of the unclaimed and unredeemed settlement value under the cap will be distributed to class members who are specifically Canadian educational institutions. So they get a chunk of that in the form of technology vouchers after the first set of enterprise class members go through their claims and redemption period. The final settlement agreement was executed in July. So we had a 6-month period going from term sheet to the final to hammer out the details. And then of course it was approved 6 months later in December, and settlement administration is obviously ongoing and will go hopefully not into the next decade, but at least 28 or 2029. So that's the background. And I just give you that so you understand a little bit of setting. But what I really wanted to get to is the mediation. As I as I sit back today, several years after the fact, I sat down and I tried to think through, why did it work? What were the features? What were the structural elements? Why did I think this was something that we could get done, and ultimately did get done? And it really came down to sort of 5 elements: timing, architecture, process, or I guess structure is another way of putting that, relationships, grit, and then the balance of creativity and pragmatism. So let me just take those one by one. I think, as you all know, timing is critical. I've found over the years in negotiating a lot of settlements, many settlements, both mediated settlements and settlements without the aid of a mediator, they usually happen at a time of peak uncertainty or crescendoing uncertainty. Often that uncertainty is at a peak during trial, as was the case here. It's when there's uncertainty on both sides that you tend to find those incentives to align, to try to reach a deal. I wish, honestly, and maybe some of you can put your minds to this and figure out how we can do this better. I wish, honestly, we could find ways to settle cases before we spend 14 years and a lot of resources and time and money litigating them. I just haven't quite been able to crack that nut yet. I do find that the timing usually works later in the day, and that was certainly the case here. So I use the example of the Shanghai communique here, because that was a time of peak uncertainty. Obviously, China had broken with the Soviet Union. There was a lot of, with the height of the Cold War, a lot of uncertainty, both on the Chinese and the US side. And it was time to sort of reach a pragmatic recognition. So let me then move to I think really one of the things that I thought was key here, and would be interested in views from this group, maybe in the Q&A period. But the architecture and process here, for me, when I reflect on it, I think it may have been one of the keys. And let me start by explaining what I mean by avoiding the pitfalls of Versailles. The Treaty of Versailles, as you all know, was struck in 1920. It was a so-called peace treaty, but of course, Europe was back at war 18 years later. So it was not very successful. In fact, it was an utter failure, if you look at it through the lens of history. And when you pull it apart, there was really no attempt to get buy-in. The structure and the whole framework of it was not one that was really grounded in getting committed buy-in from the parties. There was the treaty itself, in fact, so departed from the armistice signed by the Germans in 1918, and just became a source of anger, as many of you know. It was not done in a neutral venue. It was done at the historical seat of the French Empire. Not everyone showed up. It was really basically controlled by 3 main principals: Woodrow Wilson, David Lloyd George, and Clemenceau. So it was in many respects a structure itself that was doomed to fail. And I use that as an example, as a historical example, really as a way to look at what happened here. And by the way, I don't mean any of this to suggest that resolving antitrust litigation in Canada is the same thing as negotiating a worldwide peace treaty. I just try to use it as a historical analog in terms of looking at structure. So please bear with me on that. But when I thought about, okay, what are the things that allowed us really to avoid those pitfalls? And I'll start with one thing that I thought was interesting in this case is I found myself about 3 months or so before the mediation in a blizzard in Toronto, and maybe it was a couple months. It was December, I think, of 2017. The mediator, who was based in Toronto, called a meeting to talk about structure and process. and he wanted me there. And I thought that was interesting because so many mediators today, they just deal with the outside counsel. You know, certainly during the setup period and during discussion of ground rule structure, you know, how it's going to be architected, et cetera. You know, obviously they deal with principles during mediation itself and often during ensuing negotiations. But I thought it was interesting that this for whatever reason, this mediator wanted me, you know, the principal on one side there, wanted the principal on the other side, lead trial counsel there. And I remember asking myself, what am I doing in this snowstorm? Why can't the outside counsel just work this out? And report to me on what's going to go down, and get my feedback. But in retrospect, I think it was really important. It gave the mediator an opportunity long before the mediation even started to really set, you know, his ground rules and the framework, you know, and go through what mattered to him, and start to really, you know, develop a relationship. And so I thought that was an interesting point. And in retrospect, I thought it was very effective. What's another element or structural element of this? We did select a neutral venue. Unlike Versailles, we chose a place to conduct the mediation that a city where no one lived. We did the mediation in San Francisco. Everybody had to fly in, and I think that was important. A third interesting element is that we split the mediation very intentionally into two separate 2-day tranches. And I was skeptical of this at first. I thought, you're not going to get anything done during the first 2 days, and it's going to be a waste of time, or it goes so poorly that, at the end of 2 days, everyone flies home and just, throws in the towel. But in retrospect, I thought the 2 days and then 2 days was a useful way to allow a cooling off period, allow some shuttle diplomacy. It gave I think both sides an opportunity to go back, confer with their sort of secondary and tertiary stakeholders, perhaps. So I thought it was an effective and interesting way to do it. The final
John,
piece,
John,
yes.
if I may ask, how was the agenda structured so that there would be a more or less natural breaking point after the first 2 days?
That's a good question. I don't have a clear recollection that I don't think the mediator was very prescriptive about saying, here's where we want to get by the end of the first 2 days. I would say, when I think about it in retrospect, he really did use those first 2 days to really just dive in, really wallow in the detail. And there was not a lot of actual negotiation. There were some offers made and sort of some back and forth, but a lot of it was really just what was sort of wallowing in the detail, which, at the time always feels like you're wasting your time. But then when you go back and think about it, I think clarity often comes out of a period of wallowing in the details. You don't start with clarity and then go to details. Anything, Jeff, anything else?
No, please go ahead. Please go ahead.
Great. I think the last piece here, I would say, in avoiding the pitfalls through how this was architected, is that everybody showed. And by that, I mean, all of the lawyers from Quebec, all of the lawyers from Ontario, all of the lawyers from British Columbia, all of the lawyers from Iowa and Minnesota and Wisconsin and New York, and the places where we had litigated these cases where the U.S. class counsel had a stake. So everybody was there. And, I've found, and I'm sure many of you found, that when you don't have the stakeholders there, when they're not suffering through the process, when they send emissaries who don't have any authority or power, mediations just don't tend to work very well. And it's a very basic point, but I've just found it over time. So I think all these elements really were a key to avoiding the, the pitfalls of Versailles, as I like to call it. And when I think back, very important to the ultimate success. Another, I think, key here is that we had actual relationships. And again, I don't mean to suggest here that this was in any way comparable to the historic transition of power in South Africa, but I've always been interested in how people that have a fraught relationship or very rough history can still talk. And I love this quote because it shows that both of these men, coming from an incredibly turbulent history, did try to find the human being in the other. So I think that's just really important. I think people, and we had that here. There was respect and decorum on all sides. There was a lot of history. A lot of it was unpleasant. But when I went to Vancouver many times and sat in the courtroom and chatted with the lawyers on the other side, and we'd chat about skiing. The lead trial lawyer and I are both avid skiers, so we'd chat about skiing and Whistler and runs at Whistler. I think that's a non-trivial part of actually getting to a resolution. And I do think the lawyers that feel like the lawyers that think they're being effective by being obnoxious or mean-spirited or, sort of engaging in ad hominem attacks, they think they're being effective. They're really not, in my view. So, we did have that. I think we worked hard at it. My lead counsel in the case was highly respected, very principled person. I think that's part of what made this work. The other thing I would say is, they're obviously in any negotiation, like this case, it went on for 14 years. I mean, there is some grit to it. And then when you realize you've got just a framework in February, and you got another 6 months of hard negotiation to get to, a resolution on the details, I think it does require you just kind of have to gut it out at times, and realize that it's hard work. Again, if you have the relationship, I use this example of the NPA, the Non-Proliferation Treaty, because it really did require not just hard work during the several years of negotiation by the multiple nations that worked on this, but it required a lot of hard work to actually put it in place and make it work. And that's sort of like class action settlements and administration, because it's not pleasant to it's not like you settle a class action, go like this and go home. You've got another decade or more often of administration where you've got to deal with people. So I think that, I think grit is important. Finally, I would say the creativity and pragmatism is something that I have come to appreciate. And again, I don't mean to suggest this historic agreement, is in any way, or our settlement was in any way equal to this historic agreement. But again, I look for historical examples of where pragmatism wins out. I really do believe that, one of the key jobs of mediators is to really lead the parties to a place where they realize that pragmatism has to trump whatever principles they think they have or whatever their beliefs may be. And I think often to get there, you need some creativity. I find that mediations where you get stuck on one thing, that's often where they founder. And creative mediators are often able to avoid that. They see that there are a bunch of different pieces working in tandem or in parallel. And, when they get stuck on one thing, when the parties get stuck on one thing, a great mediator can reshuffle the deck, kind of start over, talk about some other things, see if you can get some alignment, and see if you can get to a point where you've got some alignment on some other things, and then come back to the harder issues and realize that, those harder issues that you were stuck on at the beginning are not ultimately a barrier. And I felt that we were able to do that here. I thought the biggest impediment to this settlement had been, through the course of the 14 years, frankly, the fact that, everybody on the plaintiff side seemed to be stuck on the structures of the U.S. settlements of more or less similar cases. And we just weren't prepared to go there. We thought that we were in a different place, different law, different time. And that it didn't make sense just simply to import the structures from the United States into Canada. And that became a sticking point for a long, long time. And, by hook or by crook, this mediator helped us get past that and over it, and find some alignment. And, the ultimate settlement allowed Microsoft and the plaintiffs to put a lot of valuable technology into the hands of Canadian schools. That's a win-win in many ways. We want to put technology into Canadian schools. Microsoft technology is valuable to the class members on the enterprise level. They're vast majority of whom are current Microsoft customers. So, we were able to get to a place where we use Microsoft technology as the means of settling the case. And I think it took some creativity and just basically a balance of creativity and pragmatism to get there. So let me stop there. Those are really the key points, and I'm happy to answer any questions that you may have.
Jon, thank you. That's fascinating. We appreciate it very much. There's plenty of questions. Let's start at the end when you talked about creativity and pragmatism. Where does creativity come from in a mediation? And what do you do, and what do you like mediators to do or not to do in order to be the catalyst for people's thinking in a more creative direction?
Boy, that's a great question. I think creativity can come from anywhere. It really can. It can come from any of the participants in the mediation. It can come certainly from the mediator. It can come from either side. It can come from the client, from the client principals, or it can come from the outside counsel. I think one of the ways to think about it is really to look at what is the sticking point here? What are you getting stuck on? And is there a way to address that? And I feel like that was sort of the turning point, if you will, here is we're stuck on a structure that, the US lawyers who had litigated these cases for years were very committed to importing, in essence, to Canada. And when you really looked at it, said, is that really, is that what do the Canadian parties really want? And what does Microsoft really want? And can we get there in a way that doesn't use this structure? And then that opens up creative thinking, because you start to think through, you're not thinking about the hurdle anymore. You're thinking about what's on the other side of the hurdle, if that makes sense.
Mm-hmm.
You're not looking at the barrier, you're looking at what's around the barrier. And then I think that does spawn creativity.
Now, you mentioned that this mediation took place during the trial.
That's right.
That's amazing. Was there a jury impaneled?
No,
a bench trial.
It was a bench trial, and I should say, it was a very unusual trial procedure that was set up, really a bespoke trial procedure set up just for this trial because of its complexity. So we had a judge in Vancouver who himself was very creative, excellent judge, and he, together with the parties, really put together a pretty novel, at least in terms of Canadian procedure, process for getting through the issues. I would liken it for those of you who've participated in like an ICC arbitration, in many ways, it was more like an ICC arbitration than it was a trial in a US sense. So a lot of briefing, testimony submitted on the papers in direct, and long gaps of time, and dealing with issues sort of seriatim. So it was an unusual trial in that sense.
So did the judge say, why don't you all think about mediating? Was it the suggestion of a lawyer? You're in the middle of a trial, everybody's girded for battle. How did you get into a mediation in the middle of a trial?
I think we got to the point really where for the first time in 14 years, we really joined issue. There was clarity on both sides. You know, sometimes you can't really assess your risk, and you can't really assess uncertainty until you see what you've got. I mean, what are the economists actually going to say under oath? What arguments are you ultimately going to rest on? On what things does the case really ultimately turn? And, you know, I wish I could find a better way. I wish we could I wish we could achieve that understanding and that clarity, you know, in year 2 instead of in year 14. But sometimes it really does it takes sort of the crystallization of issues at trial or right before trial. I don't know what I'd be interested in feedback from this group. I would say probably I should actually count. I mean, I would say at least 80% of the cases that we settle through mediated settlements are basically on the eve of trial, if not during.
So if you are both on the plaintiff side and the defense side, with an enterprise as a company as big as Microsoft, what advice would you give to plaintiffs, and what advice would you give to defendants in terms of trying to get that clarity or crystallization, the joining of the issues earlier on in the process so that you could make an intelligent settlement?
I think there are some creative ways to do that in US procedure. I'm a big advocate for testing legal issues early in the case. If you identify a legal issue that you think really is a fulcrum point for the litigation, you know, if you win on this one, you're golden, and if you lose on this one, you know, it's going to be a long, hard slog. Why not tee those legal issues up earlier in the day? And I try to do that. I'm a big fan of that. If the other side is willing to do it, or if there's a way that we can do it, I would rather get the critical legal issues litigated early, because I think they do tell you a lot. You know, another way is in very, very rare instances, but I've seen it done. I've done it, and when we can do it, it works. Sometimes you litigate damages or quantum first, then you actually know what you're fighting over, because it's usually the inability to get a fix on the ultimate damages range that really hampers the ability of the two sides to come together and reach an accommodation. If you actually know how big the pie is that you're dealing with, and then it changes the dynamic. So I think there are some creative ways to do that. What I find is it does take both sides, a willingness from both sides to try to try, and often, you know, you don't have that. Often you don't get an agreement to mediate until the bitter end.
In terms of getting those legal issues teed up early, what are the procedural vehicles for that? A partial summary judgment, something else?
Yeah, partial summary judgment. Obviously, motions to dismiss. You can tee up legal issues. You know, if a lot of it also depends, and then the damages piece that I was saying. I mean, sometimes you can actually get what I would call a reverse bifurcation. You know, you can try damages first. Sometimes it means trying causation. You know, sometimes it means, so another procedural vehicle you can use is actually Daubert hearings or 702, seeing if the expert testimony is going to stand up. I mean, I'll use one example of that in the US cell phone litigation. Just got a ruling knocking out all of the plaintiffs' causation experts. These are the cell phone cancer cases where there are thousands and thousands of them filed. And in the DC court, just essentially knocked them out on a Daubert ruling. There's no point in going forward in litigation if you've got no causation, and you might as well test that issue early if it's one that really is critical. So I think there are a number of procedural vehicles that can be used. I wish people were a little more creative in using them, and I wish we could come to agreements to do it, but it's a process.
So, John, let's go back to the trial situation in Canada, and let's pull back the curtain a little bit on a subject that's of great interest to mediators. You're there, everybody decides mediation would be a good idea. You're in a foreign country or another country, not where you live. How did you pick the mediator in that case? And what can you tell us more generally about the selection of mediators, and what makes mediators appealing or unappealing to a very significant consumer of mediation services such as yourself and Microsoft Corporation?
Well, there's a lot there to unpack. I do think, let me start with the first question. How do we select this mediator? This mediator was well-known mediator to both to the class counsel and to my outside counsel. I think it was there, frankly, in this instance, once we decided to mediate, there was not a lot of back and forth about who the mediator would be. I think both sides recognized this fellow as someone who is capable of getting his arms around the complexity of this case, and somebody that was a plain talker and would set the ground rules in a way that if it was going to get done, he was a pretty tough guy. I don't have a preference, frankly, for style of mediation. I think, just like being a lawyer, I think every mediator brings their own personality and their own skill set and their own abilities and history. And I think there are a number of styles that can be effective. I mean, I've seen very effective mediators that never raise their voice. They never get above a modulated, they're almost like, marriage counselors or something like that. And I've seen mediators that really take people to the woodshed and just, will get in your face. I think both can be effective if that's who you really are. The ultimate measure of good mediators are the ones that are effective. And I think there are a bunch of different ways to be effective. There are some, I do think in some cases, particularly where you have to get court approval of a settlement, it does make sense to get it to be able to say in court that you reached a mediated settlement with a prominent person, whether it's a former judge or prominent mediator. But other than that, I think it's the measure of mediator effectiveness is effectiveness. Are they able? Do you have prior experience with them? Are they able to get a case resolved using whatever tools they have? And there are a number of mediators that fit that bill, and they're of all different types and backgrounds that I would gladly hire as long as the other side agrees to it. But their track record is important. Their track record with us is important.
What gets a mediator off your list?
So I have a pet peeve with mediators that just tell you their view of the law. It's sort of like that's it, or their view of the facts, and they're not a judge. That's interesting, but if that's all they do, that's not. I find that to be you unfortunately find that with a lot of settlement judges, in cases in the United States where, that you have mandatory settlement judges with a magistrate judge or whatever. And they're not, some of them are effective mediators. Many of them are not. They just simply tell you what they think, and then you're left with that. So that's a pet peeve. I think mediators have to work harder than that. They're not just there to tell you what they would do, how they would rule. That's not going to get it done.
So you mentioned a couple minutes ago mediators who are plain talking, straight shooters, things of that nature. What is the distinction between the mediators who are straight shooters, plain talking people, straight talking people, versus people who just tell you their view of the law and expect you either to, do what they say or the mediation is done? What's the difference?
I think the difference is, I should clarify. I certainly don't mind mediators telling me what their view of the law is or what their view of the fact. It's just, that's not sufficient, right? I mean, they can't stop there. So your question about what is the distinction between the effective plain talkers and the ones that just tell you, what their view is. I think you got to roll up. They have to roll up their sleeves and do more than just say, my instinct is this, or my off the cuff thinking is this. Got to roll up their sleeves. I do think I use the term, wallow in the details a bit, and really try to figure out what's going on. And then really, to go back to the old, famous book that I'm sure we've all read, or Getting to Yes, or, really trying to figure out what the interests are of the parties. Like, what do they really want? It's not what their positions are, not what the principles that they don't want to breach, not what their beliefs are, but what are their ultimate interests? What do they really want to get out of this? Is it, and I think when you do that, you find that most parties are there at that mediation because they want peace. And when you start talking about what that peace looks like, as opposed to what the barriers to getting there look like, I really think you can be quite effective, and it's different in every case. I think about it like I'm a skier. When you're skiing through trees, when I taught my kids how to ski trees, you don't look at the trees, you look at the gaps between the trees, right? And that's how you navigate your way through the trees on skis. It's not by looking at the trees, it's looking at the gaps. I think good mediators look at the gaps. Let's not focus on the barriers. Let's focus on where what a pathway can be. I don't know if that helps. It's a little metaphorical, but it can look different. It can look like different things in different contexts.
Absolutely helpful. Not looking at the obstacles, looking at the opportunities. So, Jon, in the cases that you handle, you have very sophisticated outside counsel. You have very sophisticated business executives within Microsoft with whom you work. Can you talk a little about the division of responsibilities in a mediation between your sophisticated outside counsel, yourself as the sophisticated in-house lawyer, and the sophisticated business executives with whom you collaborate in your organization?
Yeah, another great question. It can depend a little bit based on the type of case. Generally, I will say I value, appreciate, and depend on sophisticated, competent, highly competent outside counsel. When it gets to a mediation, I generally take on a very major role, and as really generally the primary negotiator. And I expect the lawyers that work for me to do the same thing. So if they come to me to ask for authority to settle a case, I want them to be, they need to lead that. And so, that's obviously not true when you're in trial or in the courtroom, but in a mediation context, that's generally what we do. And that means developing the relationship with the other side. That means really rolling up the sleeves and understanding and being deeply invested. I want the lawyers on my team to be deeply invested in the process. You asked about executives. It really does depend often on whether is this just a negotiation about money, in which case the business executive probably is more likely to say, I'm fine, go handle this in any way that you think is best, right? Let's just get the best deal we can. If the negotiation involves actual business practices or things that your executives are going to have to do or have to bless, changes that they have to make to business practices or products, obviously they have to be deeply involved in the process. They're not usually at the mediation itself. Sometimes they are, though. I've taken senior business executives to mediations because I felt like they needed to be there to make decisions on the fly as to what we were going to do with a particular product or service. So it can depend on the circumstances.
Jon, we have just a few minutes left. There's one other area I got to ask you about. You work in an organization, a company that is at the very cutting edge of technology and changing the world through technology. Let's talk a little bit about artificial intelligence. If you have any general views as to the subject, it's so much in the news. How has artificial intelligence changed your job lately? And what impact do you think the growth of artificial intelligence will have on lawyers and more specifically mediators and mediation?
Boy, I haven't gotten yet to the mediation and part of it. And it's interesting that you asked that question because someone asked the very same question of me last week, whether they felt that there was a role for AI in a mediation context. I should just start by saying I am no expert whatsoever, and I can't speak for Microsoft on this. What I can say for myself is the technology is revolutionary. I look at it in terms of going back to the steam engine or the printing press. That type of I think ultimately will be like that. It will fundamentally change the way many of us work. The metaphor that Microsoft uses is co-pilot. We don't view AI as an autopilot. It's a co-pilot where if you need a first draft of something, that first draft can be drafted by an AI tool. And I think that is going to change. And in terms of the ability to synthesize and summarize large amounts of information, this tool, it has revolutionized the way all of that is done across many different dimensions. So I think it's very obviously going to have an impact on, if you think about what much of what lawyers today do is act as synthesizers of information and distilling complexity into simple or simpler, clear points. And that AI can help with that. I don't think AI can replace it, but it can help with that. So, I think that will translate into the ways in which lawyers ply their trade, and mediation is one of those ways, and can be a big help ultimately in helping the parties distill, large amounts of data and really understanding, and that clarity, I think, is always good in getting to a solution. But in terms of very specific applications, I'm still working on it in my own head, to be honest with you.
We look forward to your further thoughts. A couple of other mediation-related questions, Jon. One topic of great interest to mediators and our clients is the opening joint session in mediations. Some people love them, some people hate them. Some people say never, some people say always. What is your view in a mediation? How much of it do you expect to be just shuttle diplomacy by the mediator? And how much is the direct communication between the sides, given what you described as the active role you want to play in the negotiation?
So, Jeff, this is one, I'm glad you asked that question, because my view has changed over time on this. When I was an outside lawyer, practitioner, representing a client in mediation, I did not like the opening plenary sessions. I felt like it was a lot of throat clearing and a lot of posturing, and I already knew what everyone was going to say. Boy, I remember a multi-day mediation in San Francisco years ago where we just had endless plenary sessions, and I remember just being like, let's get to the point, right? And so as a practitioner, I didn't like them, and I would often go into a mediation and say, I don't want it. Let's just get to business. Interestingly, as a client, I have changed my view, almost 180%. I'm not saying that they're always useful. They often, can be a lot of posturing and so forth. But as a client, I actually think they're valuable. I like to see the lawyers react. I like to see the reaction to the mediator in the room. I draw a lot of insight. I feel like I draw insights from just that interaction together in the room. I even sometimes draw some insights about my own risks, and sometimes I draw insights about, the strengths of my case. So I have changed 180 degrees. As a client, I would say I like them, and as a practitioner, I really did not. The other thing I would say is, as a client, I find that when you go to the relationship piece that I hit on, I learned something from a lawyer that I hire that works for me. And I thought it was wonderful. In every mediation in the opening session, let's say it was a business deal that went south. Let's say it was an employment matter where an employee is filing claims for discrimination or whatever. She finds a way to say, hey, I'm really sorry this didn't work out. I'm really sorry we're here. And, this is not where we want to be. Let's try to work together. We've got jobs to do. And she has this sort of great way of, really, again, going back to that relationship piece. And I think that's valuable. So I've learned that from her.
The sense of human connectedness that's quite different than an acknowledgement of responsibility or
Right.
an admission of fault or blame, right? So just that point of human connection can really go so far.
Yeah.
And then finally, Jon, we talked about the beginnings of mediation. What about the ends of mediations, closing techniques, mediators' proposals, or last, best, and final offers? Are there things that you think generally work well or generally don't work well in terms of closing that last gap and getting a deal done?
Hey, I'm a big fan of mediators' proposals. I am. I would, I'll say to close that last gap, it is often the difference between getting a deal done and not getting a deal done. And I would say more than 50% of the time, in my experience, those mediators' proposals have worked. And that is an illustration of the value of mediation, where, the two parties may not have gotten there on their own. So I'm a big fan. I have a last and best. I don't know. I'm not quite as sold on that. But I do like the mediator's proposal.
When we mediators hear that, we often think last, best, and final for the time being.
Yeah. Yeah.
Right.
Yeah.
So we have just a minute left. With respect to mediators' proposals, can you distinguish what are the circumstances, what are the things a mediator can do to increase the likelihood that it'll go well as opposed to go badly? What's the difference between a well-done mediator's proposal and a poorly done mediator's proposal?
Jeff, I don't know how to answer that question really, other than to say that, mediators, good mediators are students of human nature and have developed by the end of the mediation, or by that point in the mediation, good mediators probably know more about each side than the other side knows about the other, despite the fact that they've been litigating for however many years and have been in court together. And but I think that just the process of the mediation itself, the great mediators really do develop a sixth sense of where that signal. And so I just feel like often I see in the mediator's proposal, they've hit it. They've hit exactly where my sort of breaking point is. And they're successful because they've hit where the other side's break, so I think it's an alchemy, really, that a good mediator really is a student of human personality and the dynamics. And this is, again, I go back to, and the facts. I mean, I think mediators need to roll up their sleeves and actually understand the cases, but the good ones just know where that point is. I can't explain it. As I said, I'm not a mediator. I'm just a consumer of mediation services. But
well, I can tell you that the wallowing in the facts that you described earlier in the process, as mediators, we can pick up a lot of hints and a lot of clues that pay off later in the process.
Right.
So very
Right.
happy to hear that you're an advocate of that kind of elaborate process and talking about things before we just get to the bargaining. What do you want to pay? What do you want to take?
yep.
With that, John, believe it or not, we're out of time. The hour has flown by. Thank you so much. I know that many people will be contributing to the University District Food Bank in the state of Washington in your honor, and we will raise a lot of funds to fight food insecurity in the state of Washington and elsewhere as a result of this wonderful presentation. Jonathan M. Palmer of Microsoft Corporation, thank you so much. And with that, we are complete.